Hello everyone. So let's continue with our legal series of class 12, wherein we were doing the first chapter, that is judiciary. We have covered the various courts, hierarchy of courts, and how Supreme Court intervenes, how it takes a suo motu, and all those things. Now comes the next topic, that is role of Indian judiciary. The role of courts. Indian judiciary comprises of Supreme Court, High Court, subordinate courts. Role of these courts along with their composition. Okay, now let's different roles of Supreme Court of India. Supreme Court primarily exercises role of an adjudicator and interpreter. This is explained through different jurisdiction vested with the court. Its role as an adjudicator and interpreter can be understood through the original and appellate jurisdiction vested with the court. Original jurisdiction is when the cases directly come to the Supreme Court and they hear that. Appellate jurisdiction is when the cases from lower courts come in appeal or as an appeal to be heard in the Supreme Court. अपील तभी किया जाता है जब लोअर कोर्ट्स के वर्डिक्ट से जो पिटिशनर है वो सेटिस्फाइड ना हो. Under Article 131, Supreme Court is granted original jurisdiction. Remember the articles. Article 131, Supreme Court, original jurisdiction. Power exercised is to adjudicate amongst disputes between union and one or more states or between two or more states. Such disputes must involve some question of law or fact on which the existence or extent of legal rights can be adjudicated. Means the disputes or the cases which come into the Supreme Court, it must contain a valid question of law or fact on the basis of which the cases would be heard and the matter could be resolved. For example, dispute between sharing of river or other natural resources between two states in India can be directly brought to the Supreme Court under exercise of its original jurisdiction, as Article 131 provides that disputes between two states or dispute between a union or the states can be resolved, can be taken up as an original jurisdiction. So, when as the example is given, a dispute of sharing of water or any other natural resource between two states of India can be directly heard up in the Supreme Court, or it can also go into the High Courts for hearing. And after that, if not satisfied, then appeal can be made into the Supreme Court of India. Article 32 further gives an extensive original jurisdiction to Supreme Court for enforcement of fundamental rights through issuing directions, orders and writs. This is popularly known as writ jurisdiction of court. So Article 32, 131 is what? Original jurisdiction. Article 32 is writ jurisdiction of the Supreme Court, wherein it can enforce or it can hear the cases which are in the violation of fundamental rights of the citizens by issuing writs. There are 5 kinds of writs. Okay. Appellate jurisdiction can be invoked by a certificate granted by the High Court. Appeal to the Supreme Court may be made against any judgment, decree or final order of a High Court in both civil and criminal cases. किसी भी टाइप की अपील हम कर सकते हैं, किसी भी जजमेंट के अगेंस्ट हम अपील कर सकते हैं, चाहे वो सिविल केस हो या क्रिमिनल केस हो. Like the exercise of original jurisdiction, these cases must involve a substantial question of law as to the interpretation of Constitution. Substantial questions of law as highlighted above, cognate questions of law or fact on which existence or extent of legal rights can be adjudicated. Means the question or the fact of law on the basis of which the cases would be fought, the matter or facts or merits of the cases would be presented in front of the judge, and on the basis of those legal rules or legal articles which are mentioned in the Constitution or various legal books like IPC, CRPC, on the basis of those laws only the final verdict will be announced and matter or the suit will be resolved. Apart from the listed appellate power, Supreme Court also has wide appellate jurisdiction over all courts and tribunals as provided in Article 136. Under this, the court may grant a special leave to appeal and receive any judgment, decree, determination, sentence or order in any cause or matter passed or made by any court or tribunal in territory of India. So, as per the Article 136 of Indian Constitution, Supreme Court has wide appellate jurisdiction. It can give a special leave petition. You may have heard this word, special leave petition. These are filed, and any judgment, any order can be received which is passed by any lower court of India. It may be a tribunal, it may be a subordinate court, but if the person wishes so that he directly now wants to go to Supreme Court for the matter, not to the High Court, he directly wants to approach the Supreme Court if not satisfied by the verdict given by the tribunal, then he can go, and that is through the special leave petition which he can file, special leave petition or special leave certificate, whatever you may say. And this particular thing is mentioned in Article 136. So please remember the articles. In earlier lecture, it was Attorney General and Advocate General, of which we have learned the articles of, like Attorney General, Article 65, Article 165 was of Advocate General, that is at the state level, and Article 76 was of the Attorney General of India. Now in this, Article 32 is writ jurisdiction of Supreme Court. Article 131 is original jurisdiction of Supreme Court. Article 136 is the special leave jurisdiction, okay? And also, as it is about writ jurisdiction of Supreme Court, similarly there is a writ jurisdiction in High Courts also, and for that Article 226 of Indian Constitution is there, okay? Besides being an adjudicator and interpreter, Supreme Court also functions as an advisor. Court's advisory jurisdiction may be sought by President under Article 143 of the Constitution. Means that President, if he wishes so, can take the advice of court in some matters, and this is given as per the Article 143. This procedure is termed as presidential reference and recognized as advisory jurisdiction of the court. Under this, President may refer any question of law or fact of public importance. However, it is not binding on Supreme Court to answer questions raised in the reference. In the last more than 60 years, only a handful of references have been made. The Supreme Court can refuse to provide its advisory opinion if it is satisfied that questions are either socio-economic or political in nature. It means that the President can ask any question of law related to law from the Supreme Court, but it is not binding on the part of Supreme Court to answer all those questions. And in last 6 decades, only very few questions were asked, very few references were made to the Supreme Court, and it is on the Supreme Court that if it considers the questions coming under the socio-economic criterion or political criterion, then it is under Supreme Court's wish that whether it would provide the advisory opinion or not, and rather it can refuse willingly also. So far we have seen the constitutional imperatives that permit Supreme Court to adjudicate and advise on disputes coming from subordinate courts, individuals exercising writ jurisdiction, and President of India. So we have seen that the Constitution allows Supreme Court to advise on matters relating to the cases which come from lower courts or individuals who have filed writs and the President of India. In recent years, Supreme Court has relaxed its locus standi. Now, what is locus standi? The right of a party to appear and be heard by a court, and has permitted public spirited citizens and civil society organizations to approach the court on behalf of the victims for better administration of justice. So what Supreme Court has said, it has relaxed its locus standi, means it has made its arena of considering or hearing the cases more broader, and it can now hear the cases through some NGOs or civil society organizations, so that the justice can be brought to the common public in a more administrative and more easier or enhanced manner. On other accounts, Court has on its own initiative started cases of public importance. As I said, it may take suo motu cognizance of some of the cases in which the political parties is not taking any heed and they are not paying attention. Then if the situation is deteriorating, then Supreme Court can come forward. It can take a suo motu cognizance and work on it. Okay. For instance, it has summoned and reprimanded state authorities for their apathy and lack of diligence in running child care homes in the states. All this has been possible through judicial activism of Supreme Court through PILs, which is also called Janhit Yachika. See, public interest is Janhit, litigation is Yachika. This extraordinary jurisdiction has been invoked either through writs or by writing letters to judges whose modalities are maintained under the guidelines for PIL enacted by the court. First ever PIL was in Hussaira Khatun versus State of Bihar and dates back to 1979. Okay, so I think this is enough for today's lecture from this para. The first ever PIL I will do in the next lecture. Okay, thank you.